So good morning, everyone. I hope you're keeping well and looking forward to today's event. Today's event is titled Employment Law, What to Expect in 2022. Really quickly, just to introduce myself, my name is Molly and I'm the Events Executive here at Kent and Medway Chamber. I'll be hosting today's event and today we are joined by our guest speakers, Andrew Masters and Tessa Robinson as well from Furley Page Solicitors. Before I pass over to them, if I can quickly say that do try and keep your microphones on mute for us, unless of course if you've been asked to unmute for any questions or anything like that, of course feel free to unmute them. Otherwise do try and keep your cameras on for us as well. It really does make a difference to the speakers when they can see that you're engaged in the conversation, nodding along, rather than talking to a load of blank screens. The chat function is open as well, so if you do have any questions, pop them in there for us, and we've allocated time this morning to make sure that we get to go through them. Really short and sweet from me. I think that is everything from me for now. I will now hand over to Andrew as our first speaker.
Thank you, Molly. Good morning to everyone, and thanks to Kent and Victor for all their hard work in putting this together today. So we are speaking on the 19th of January 2022, so the beginning of a new year. Now, one of the questions that I've been asked quite a lot in the last year or two is, why has the pace of employment law slowed a little bit? Well, I think that is an interesting question, and we'll try and answer where we might be going during the course of the next year, 18 months in this hour slot this morning. So a quieter period of employment reform. Well, the government, I think, has been pretty tied down with Brexit and the Brexit negotiations in recent times, and perhaps their priority has been there. And of course, we've had the small matter of a COVID-19 pandemic, which has been going on now for the best part of 2 years. And of course, all of us will remember the huge amount of work and how quickly we had to get up to speed with furlough. So, and of course, perhaps the biggest reason of all is not to do with those at all, but I would never prejudge the outcome of Sue Gray's investigation report, but it might be they've been partying pretty hard as well over the last year or two. So we'll see. A good HR stroke lawyer should never prejudge the outcome of that investigation report, but they have been very busy. They've had a lot on. And I think what we are likely to see this year in 2022 is more employment reform. And as I said, I think it's a good time to be looking at this particular moment in time. So what I also wanted just to give is a sort of macro overview. And will 2022 be a difficult year for employers? Well, I'll let you judge, but I think it could well be a very difficult year for employers. We have national insurance increases for employers and employees in April. As we know, that is in relation to the NHS and then social care bill from 23. We also have increases in the national living wage and national minimum wage from April 22. I've got some figures here, and the national living wage, that's for those employees of 23 and above, is going up to £9.50 from £8.91, and that is a 6.6% increase. The 21 to 22-year-old rate is going up by 9.8% from £9.18 to £9.18 from £8.36. So in percentage terms, quite big rises, which will obviously have to be met by employers. Whether they pass it on to customers and clients, obviously at this stage, we don't know. Also, we have the sort of global issue concerning energy costs. And again, that's going to be a cost burden for employers. And that will be relevant in terms of energy, obviously fuel costs as well, transportation costs will also be added. Not surprisingly, there are inflationary pressures in the economy. And I think the latest figure, which was, I think either came out today or yesterday, said that we're currently up to 5.4% in terms of inflation, when the Bank of England's target is 2%. So there are issues there in terms of inflationary pressures, and we're back to the early 90s there in terms of those inflationary pressures. Inevitably, this will lead to interest rate rises. We had a small rise. I mean, by historical standards, they are very low still at the moment, but we are potentially looking at 2 or 3 more interest rate rises in 2022, the first of which could be next month in February. So I think, again, that's going to put pressure on employers. And the other issue, and I don't know what people on this webinar, how they're experiencing this, but the whole issue around recruitment and retention at the moment is much harder than it was, or certainly from my perspective, it's been it's a much harder task now than it was a few years ago, and that's across all sectors, and several, well, pretty much all of my clients are telling me the same thing at the moment, that they have vacancies. So it's a very interesting time in the UK economy at the moment, but without doubt, in my judgment, there will be pressures on employers. And I think when we look at some of these potential changes, that is the backdrop. So moving quickly on, those of you that attended our webinar in September will recall that we talked a lot about flexible working and hybrid working. So I put up there on slide what the current position is in terms of make the flexible working process. And this is largely mirrored in handbooks that with clients that I represent, and I'm sure if I don't represent, they're in your handbooks as well. So the employee makes a formal request. They must have been employed for at least 26 weeks at the time of the request, and they've made no previous application in the last 12 months. There is a 3-month window to consider the request, but if the employer disagrees, they must disagree on the basis of 1 or more of the 8 prescribed reasons which are set out in the Employment Rights Act. And just briefly, I'm sure you know this, but it's worth repeating. The reasons are the burden of additional costs, detrimental effect on ability to meet customer demand, inability to reorganize work among existing staff, inability to recruit additional staff, detrimental impact on quality, detrimental impact on performance, insufficiency of work during periods the employee proposes to work, and planned structural changes. So they are the 8 reasons. And as I said just a few moments ago, an employer must rely on 1 or more of those if they are to reject an application for flexible working. Now, looking at the what has been going on in recent times, the Conservative Party in the 2019 general election manifesto did indicate that they will look towards new regulations to make flexible working the default position, so different to the current situation. The consultation on changes to flexible working ended in December of 2021, so last month. Now, whilst the proposals haven't quite gone as far as to put flexible working as a default position, it has proposed a number of changes. So it would be a day 1 right rather than the 26 weeks right. The consultation is looking at whether or not the 8 business reasons which I just read out remain relevant. There's also, they're questioning whether there is the changing of the administrative process. So we would see if the process and procedure was changed. Also, potentially a new requirement on employers to suggest alternatives if they're not prepared to agree to the flexible working request that's been made by the employee. And also this issue of requesting a temporary arrangement, which can sometimes be difficult where someone, there are sort of trial periods and things like that. So none of this is yet in legislation, but I think we will see changes during the course of 2022, or at least firm proposals that would be brought in 2023, if they're not brought in 2022. As I say, it was a manifesto pledge to change flexible working. Of course, the other big issue is that I think when there are so many vacancies in the economy and it is so difficult to recruit at the moment, the power has passed a little bit to the employee in any event. And it may well be that the whilst there will be changes, the sort of commercial reality here and market forces are such that employers are going to have to be far more flexible. And we've seen that a lot with people working from home or in a hybrid capacity, which we went into some detail in September on. So that's, watch this space on that one. I think it's a very interesting development and one that will affect all of us, I would suggest. Now, the next topic that I wanted to talk about is one that is increasingly coming up in terms of legal issues and HR practices. And there's a lot written about this, not only in the HR press, but also now in the mainstream press. So it is the issue, perhaps a taboo issue, which I think it is important that we bring out and discuss today, is menopause in the workplace. Just looking at some of the stats that, it is of course a natural aging process. It isn't something that anyone should be embarrassed about, and it should be out there, I think, from an employment perspective and an HR perspective. And I hope that most people on this call will agree with me on that. But I felt it was important just to look at some of the stats. So 7 out of 10 women of menopausal age are in work in the UK. That's more than 3 million over the age of 50, 3 million over the age of 50. And obviously that doesn't include those women going through the menopause in the 40s and perhaps even earlier in some cases. The average age of menopause is 51. And as I alluded to there, the transition stage can start several years earlier. It's not a one size fits all. The negative health effects vary greatly as well. Again, there is not a one size fits all. There are both physical and psychological effects potentially for women going through the transition stage and the actual menopause themselves. So why is this relevant to our discussion today? Well, the House of Commons Women and Equalities Committee have launched an inquiry into whether discrimination legislation should be extended to automatically cover the menopause. But they also want to look at workplace practices on the basis that their starting point is that women are not adequately protected by the law in relation to this difficult issue. The other thing is that just think for one moment about the loss of talent if women were to leave the workplace because they felt they were not supported in relation to the menopause. We've already said about the huge number of vacancies in the UK economy at the moment and the amount of talent that there is. And it seems to me that this is, an issue which people sometimes are not keen to talk about, but is now increasingly coming up. But I want to obviously focus far more on the legal and consequences, if I may, rather than the health issues. So we know from numerous surveys that the menopause or the effects of menopause can affect work performance, sickness absence, and sadly, it still goes on, inappropriate and negative comments being made towards the employee. Often they are dismissive and unlawful harassment. And, I see this in my practice, and it's one of those things that I think women have often suffered in silence on, to be perfectly honest. Now, we have seen case law around unlawful age discrimination because generally it is affecting women that are older in the workplace, and we've already said that the average age is 51. And sex discrimination because, to the best of my knowledge, there is not a male menopause. So the reality is there have been cases around unlawful age and sex discrimination. But what I wanted to focus on today, and this is off the back of a recent case that was heard at the Employment Appeal Tribunal in October of 2021, is called Rooney and Leicester City Council, is can serious symptoms amount to a disability under the Equality Act 2010? So can a woman that is, that has severe physical and or psychological effects as a consequence of the menopause, can that be a disability? Hopefully most of you will be aware that under Section 6 of the Equality Act 2010, an employee or a worker can be disabled if their physical or mental impairment has an adverse effect on the ability to carry out normal day-to-day activities that is different to activities at work, normal day-to-day activities. The effect is substantial, so not minor or trivial, substantial, and the effect is long-term, that has lasted for 12 months or is likely to last for at least 12 months. So if it is that someone going through the consequences of menopause comes into those categories, then it is certainly possible that it could be deemed a disability in those particular circumstances. And of course, that would raise issues around reasonable adjustments and protection under the Equality Act in relation to disability discrimination. So it is something which I think we're going to see a lot more of in terms of the workplace. And for that reason, Tessa and I think it is an important issue as we move into 2022, and an issue that we feel should be discussed. Now, one of the get out of jail cards for some employers has been that they had no knowledge of the consequences and how this was affecting women in this particular stage of their life. Now, knowledge can be a defence in certain circumstances, or lack of knowledge can be a defence. But I think that increasingly in these sorts of cases is going to be under challenge by employment tribunals and higher courts. So the duty would be on an employer, if they have actual knowledge that it is potentially a disability or is a disability, to look at reasonable adjustments in those circumstances. And there is also a duty at least to endeavour to ascertain. Obviously, this is a private matter, and in many cases, the employee may not want to disclose some of this. But I think increasingly, if the taboo is lifted to a certain extent, which, if I may use a small analogy, perhaps not a great analogy, but mental health, I think we've seen a lot more openness about mental health in the workplace. And that's a good thing, in my judgment, as a mental health first aider. And I think, society is changing, or has changed. And I think that the law is beginning to start catching up with some of those changes. So I just put the case there. Rooney against Leicester City Council decided in October 2021. And I think it is not necessarily opening the floodgates at all to this type of claim. But once again, I think it is showing that that tribunals, and in this case, the Employment Appeal Tribunal, are going to be looking very closely at whether it is potentially a disability in the more severe cases. So I've already said that the knock-on effects, potential performance issues, sickness absence, and sadly, unwanted comments that are being made by other members of staff in relation to these sorts of situations. So what could you be doing as an employer if you're not already doing it? You may well be doing it. Well, you could introduce a menopause policy. Very much, it would be a spirit of openness and an open conversations about the issue. You could look at, again, flexible working, temporary flexible working. You could look at adjustments, risk assessments in the more severe cases, if it is that the employee is suffering with these symptoms. Uniforms is another example. So I think I'm right in saying that Tesco's have recently introduced breathable uniforms, but most of all, a more inclusive environment. This is a natural process. This is not something for anyone to be ashamed of. It's an entirely natural process that we've already know that at any one stage, about 3 million women in the workplace are going through. So I hope that that gives you at least a flavour of what I believe is going to be a big issue moving forward in terms of employment law and HR practices. But before I depart or answer any questions, I just wanted to, on the theme of disability, I wanted to mention long COVID. This is just beginning to start hitting my caseload, the concept of long COVID. obviously a new concept, one that we hadn't even heard of 2 years ago. But in October 2021, there's an estimate of 1.2 million in the UK was self-reporting long COVID. And the NHS now is beginning to start having clinics to assist in relation to this. So is long COVID a disability? Well, it could be. And once again, it will depend upon the severity, and you'll go back to the tests which I just applied in relation to Section 6 of the Equality Act. The TUC have recommended that there be an extension to the Equality Act to cover automatically long COVID cases in the same way that there is, say, for cancer. At the moment, that has not been accepted as a recommendation, but it may well be that, again, depending upon the circumstances of the individual case, it could come within the disability category. And ACAS have also recently published a guide in relation to long COVID. And if you're unaware, it can have quite significant debilitating effects, long COVID. And obviously, we're still coming to terms with it in the same way perhaps we were looking at ME 20, 25 years ago. But some of the effects can be similar in terms of debilitation and are likely to have adverse consequences in terms of work performance and day-to-day activities. So again, I think that's one to look forward to in terms of not look forward in a positive way, but look forward to in terms of potential developments in the workplace. So in short, for me, difficult environment, I think, for employers in 2022. Potential growth of employee rights, 2022, 2023, and Tessa's going to come on and talk about those in more detail in a moment. Flexible working is a big issue. I've talked about menopause. I think it's going to be a developing area of employment law in recent times, as is long COVID as we move forward. So I think I've got a couple of minutes, Molly, if there are any questions that have come in. If they're not, I will obviously hand over to Tessa.
Thank you. We did have one question here from Gareth, who asked, can we reject flexible working requests from an apprentice who essentially is on site for training/work?
Well, as the law currently stands, you can reject any application for flexible working based upon the 8 prescribed grounds, which I outlined, provided that the process is followed and the employer is able to find one of the 8 prescribed grounds or more, then the employer can reject in those particular circumstances. Now, clearly, moving forward, we don't know where the government is going to legislate on this particular point, but I suspect, particularly because they've rejected this default position, then I suspect in those circumstances there will always be the right to refuse, but there might be more of an onus on the employer to try and seek an alternative to the proposal that was made. So yes, the answer to Gareth is yes, you can in those circumstances, provided one of the 8 prescribed grounds is found.
That makes sense, thank you. And we've also had one here from Wendy, who asked, are there any standard menopause policies/resources that we could use as a basis to create one for our company?
I'm sure there are. I mean, we have our own policy that we are developing or have developed. I think ACAS might have one, so it might be worth checking the ACAS website. I would say at the moment that most employers do not have a menopause policy, but I think you'll find that may be very different in the next 2 to 3 years, Molly. But ACAS may well be a good source of to check out.
And it looks like the last one here from Margaret, it says, do you know the proportion of the 3 million women in work of menopausal age that have severe symptoms?
I'm sorry, I don't, that's a brilliant question. I don't know the answer to that. What I do know is that there haven't been as many cases that have gone through the tribunal system that I would expect yet in relation to women that have severe consequences. Now, I mean, one of the theories and research on this, and it's a very sad answer that I'm about to give, but a lot of women walk away from the situation. So in other words, they take the decision to leave their job. And this is one of the problems. I mean, I was reading yesterday that I think in people management, that up to 18% of women currently encountering early or current or stages of menopause are thinking about leaving their job. Well, at a time when we are short of quality people in the economy, and we've got all these vacancies, that seems tragic to me. It seems to me a much better course would be for employers to try and assist keeping their employees and wanting them to stay. So sorry, I can't give a precise answer to the excellent question, but certainly I think it's much more prevalent than perhaps the stats currently tell us.
Yeah, no, that's great, and thank you for your answer there as well. I hope that sort of answered your questions there, for everyone that's just asked them. Obviously, Andrew is saying around, we have Tessa who will be speaking next, but I believe Andrew is staying to the end as well. So if anyone does have any more questions, and he may be able to help you in a moment.
Of course,
please
I'll be
do.
happy to stick around. Thanks, Molly. Yeah.
Perfect. Suppose that leaves me then to just thank you again, Andrew. And now if I can introduce Tessa Robinson, who is also from Furley Page, and will be our next speaker.
Hi, everybody. I've been given the great job of telling you about all the new rights that are coming in for employees. So it's very, as Andrew was saying, kind of employee focused at the moment. And in 2019, in the Queen's speech, it was announced that there was going to be an employment bill, so very broadly named, to introduce loads of new rights that have come through via various consultations from the Good Work plan that we've spoken about before. Not much progress has been made on that bill for quite obvious reasons. Brexit, COVID, everything has gone static for 2 years pretty much. But it is now on its second reading. So we're hoping throughout 2022, lots of these rights may be enforced by the end of the year, if not ready in legislative form for introduction next year. So I'm just going to go through a few of them, and you'll see how actually things really are changing finally after many years of static employment law, really. So the first one I was going to talk about is the proposal for an extension to redundancy protection for women and new parents. And I do want to highlight this is for new parents as well, because people still think about parental leave being for women on maternity leave. And you'll see as I go through this that it really is focusing on the whole family unit, not just women. So at present, employees who are on maternity leave have enhanced rights throughout a redundancy process. Essentially, they have the right to automatically be slotted into a suitable alternative role where one is available in preference to other employees who are also going through the redundancy process. And that really does mean slotting into those roles automatically, not just being given preferential treatments in an interview process. The proposal is that this right to be given the suitable alternative role will be extended from the day an employee informs their employer they're pregnant and for 6 months after their return to work. You'll all know, if you work in HR or business owner who's gone through a redundancy process, when people return from maternity leave, there's quite often questions about how far the selection matrix should be adjusted for those who have been out of the business. And women who've been on maternity leave often say, well, actually, that's not fair to even have that criteria of, say, relationships with suppliers or clients when they've been out for 12 months. And these kind of just genuine concerns that are raised have been recognised by the government in saying that actually, yes, people are adversely affected when they're out for a period of 9, 12 months, however long that is. And that does need to be recognised in redundancy protection. So that is why this new right is being introduced. And hopefully that 6 months will give some sort of certainty to both employees and employers in a redundancy process. It will apply to adoption and shared parental leaves also. As I said, the bill is at a very early stage, so we don't have much detail in the actual drafting of what it will look like. The government have said that for adoption leave, it will basically mirror maternity leave. So presumably that will be from the moment an employee tells their employer they've been matched in an adoption process. Logically, that makes sense because adoption processes, the interviews, the suitability, or that side of things can take a long time to progress, and that would give them a huge level of protection before they're even out of the business. So logically, from the moment they inform their employer they've been matched. and for 6 months on their return. Shared parental leave, obviously, it's a much more flexible right. People literally come in to shared parental leave, go out again, might then go off for another period. So it's much more difficult to really assess the period of protection an employee needs once they return to work under this new proposed extension to their right. What the government have said is that that period of protection when an employee returns from shared parental leave should be proportionate to the length of leave taken. So if somebody has only been out the business for a month, that's very different to somebody who's been out for a full year. So that does need to be taken into account. And crucially, they have said that no mother should be worse off if she curtails her maternity leave to swap into shared parental leave. So when you look at this, logically, you think, well, if they're going to be no worse off, they will automatically be given 6 months protection on their return. But the question immediately is raised that, well, what if they curtail their maternity leave, swap into shared parental leave and only take a month or two? Will they still get the 6 months protection? Don't know exactly how that's going to work at the moment. And then the final point kind of feeds into that as well, that the government have said the period of protection under shared parental leave shouldn't create any disincentives to taking the shared parental leave in the first place. So you can quite logically see that actually companies have not seen a huge uptake of shared parental leave. Companies quite often still only offer enhanced pay to maternity leave. So if you're in a situation where actually that's the case, and you don't get the same protection in a redundancy situation after your return, why would a mother want to then share the leave with her partner under shared parental leave? It makes that scheme even less attractive than it seems to already be. So that is what is kind of going to be taken into account, what's going to be debated, exactly what that will be. So watch this space really, but something very much to bear in mind if you do go through redundancy processes moving forwards. Very briefly, because we have spoken about this in quite a lot of detail at previous webinars and seminars, in the same employment bill, there will be the introduction of neonatal leave and pay. And this has had a huge amount of debate around it because parents, obviously, who are unfortunate enough to find themselves in a situation where they've had a premature baby that needs intensive care in hospital after birth, that time they spend with their child under maternity leave is just not the same quality. It's just incomparable to people who are at home with their baby. So this has been recognised that actually that situation is very different, and the government is introducing 12 weeks paid leave for parents who have children who enter a neonatal unit within 28 days of their birth. The qualifying service for this right is the same as all other family leaves, so 26 continuous weeks of service, and the level of pay they will be given is exactly the same as other statutory pay for family leave. Lots of companies I'm speaking to are saying, well, actually, they would offer enhanced pay in this situation anyway, because it's such a horrendous situation for a family to find themselves in, and they just feel that's the human thing to do. So you may find that actually that's something you can do in your policies to help, as Andrew said, when recruitment's very difficult. God forbid anyone would find themselves in this situation, but it's quite comforting for people to know that actually their income is protected when they're going through a horrible, horrible time. I'm now going to talk about an EU directive, which you might find completely bizarre, and I haven't lost my mind. I have heard about Brexit. I do know we're no longer in the EU and a member state. But by August 2022, EU member states had to implement the EU Work-Life Balance Directive. So for those of you who don't know, this directive introduced baseline family and carer rights, and they wanted to create a level playing field across the EU, because what was offered for things like maternity leave, paternity leave varied so much. Now, the UK pretty much already matched or exceeded what's in this directive, but we don't, well, until now, we haven't had a carer's leave. So they recognised this was a right being introduced by the directive, and the UK, even though we went through Brexit, said we will introduce that as well. Because we're not in the EU, we don't have to introduce it by August 2022, so it's unknown as to whether it will be introduced separately or again as part of the employment bill, but hopefully we will see progress on it this week. We do have a bit more information on this in some of the other areas, because it has come from the directive and kind of been separately thought about elsewhere. It will be for 5 days leave each year, each and every year. Originally, it was going to be a paid leave, but it's being introduced as an unpaid leave for people. It will apply to employees only, so not to workers and those who are self-employed, employees only, and it will be a day one right, so there's no qualifying service required. The carer relationship will follow the same definition as who a dependent is in the right to dependent time off for dependents. So an employee will need to be caring for their spouse, civil partner, child, parent, someone living in the same household as them, or a person who reasonably relies on them for care. So it is quite wide, and again, to make it quite simple, they have kind of echoed rights that are already in there, and they will be using that legislation, and that will hopefully speed up the process of its introduction. The person being cared for must have a long-term care need. So that means that they must have a long-term illness or injury, whether that's physical or mental, a disability defined in the Equality Act 2010, or issues relating to old age. So if you kind of follow what's already in the Equality Act, disabilities, as Andrew touched on, have to last for 12 months or more generally to be long-term. So I would expect that to be the case here as well. Although the government has already recognised that there will need to be exemptions to this. Obvious example is in cases of terminal illness where the care needs might be very high, but only for a short period. So that will be an exception to the long-term care need. Employees will have to give notice if they want to take this right, so it's not meant to be used as an absolute emergency where they can literally leave the office within seconds. And the notice they have to give will echo the process for annual leave, so double the length of notice for the period of leave they need to take. And again, you can see the government are taking parts of process drafting from other bits of legislation. So although it's a new right, they're very much using old rights to help the process speed up and make it simple for employers and employees to follow. So if somebody wants to take 1 day's leave, they'll have to give 2 days notice. They can choose to take the leave quite flexibly, so it can be minimum periods of half days, but likewise they can take it in one block of 5 days each year if they do want to do so. Crucially, employers cannot refuse employees taking this leave. They can only postpone it if it will have an undue impact on their business. And given people might only request half days, logically, you can see this might be quite difficult for an employer to actually justify postponing it, unless, of course, you've got a massive conference or loads of meetings set up and it really is that inconvenient. So it's essentially one that will have to be granted when requested, except for in exceptional circumstances. Employees will be protected from suffering any detriment for requesting or taking the leave, and if they are dismissed for requesting or taking the leave, that will be an automatic unfair dismissal. So these are very much the basic rights that will be in place. Employers can, of course, go beyond this. And it's another thing that kind of makes you feel like the legislation is finally catching up with society. Like, these needs have been around for a long time now, and it's been recognised in the workplace. So again, employers, in the same case of like neonatal, you might want to offer paid leave because it's only 5 days a year. Not everyone will need it or use it. But yes, this is the minimum leave. So beware of that. It might be introduced later this year or early next year. One of the main things I wanted to speak about today, and again, this is most likely going to be in the employment bill, and there's a lot to be worked out with the detail of this. The government want to introduce a new proactive duty on employers to prevent sexual harassment in the workplace. And the reason I'm going to spend quite a bit of time on this is because I think this is potentially going to be one of the more onerous things for employers coming out through this employment bill, because it's a proactive duty. It's not something you can do retrospectively. You are going to have to engage in this process. So the new duty will be that you have to take all reasonable steps to prevent sexual harassment in the workplace, otherwise you can be liable. And immediately the question asks, well, why is that different to how the situation already is? Like, if there's an act of sexual harassment, we can already be liable for that, and people bring claims against us. The new duty means you can be held accountable for failing to take those preventative steps, even if no incident of sexual harassment has occurred. So it's a standalone. If you fail to take any steps to prevent it, you can be liable. Very much the thinking is, with everything that's come out over the past few years with harassment in the workplace, like the non-disclosure agreements, the Me Too movement, all of that, is that it needs to shift away from after the event liability to actually catch up with society and stop this happening in the first place. It's no longer okay in the modern world to just acknowledge it happens, but deal with it afterwards. And the government has set out a very clear message that that is not going to be the case moving forwards. And although I've said they've set out a very clear message, helpfully they've been very unclear about what all reasonable steps will be. And they are kind of saying they're not going to really legislate for what all reasonable steps will amount to. They did provide reasoning, though, as to why that is the case. And they've said if they legislate too strictly for it, it will remove all flexibility for a business to take a proportionate approach based on their size, resource, the culture within their own business. So it is going to go back to the old employment law adage of what's reasonable and proportionate for each employer. Slightly more helpfully, the Equality and Human Rights Commission, the EHRC, is putting together a new statutory code of practice for employers to follow. So there will be some guidance. They have openly said, though, that it's not going to be an exhaustive list of what employers should or shouldn't do. It's guidance. It's going to be what's generally expected. Logic tells you that simply having a policy on sexual harassment is no longer going to be acceptable. You're going to have to make sure people read it, potentially provide training. It's got to go that step further. It's not just we have a policy, it's up on the internet, they should have read it. You've got to make sure everybody is aware of their duties not to sexually harass people. Logically, people should be aware of that already, but as we all know, that's not the case. It does happen in the workplace. But if you can't prove that you have proactively taken those steps, you are going to be potentially liable. What would you be liable for is the big unknown question. Really unhelpful, again, of the government not to have any detail on this at present. The thinking is that actually the EHRC will be the body that investigates and enforces this new preventative duty. So kind of along the same lines that the Information Commissioner's Office enforces data protection and breaches there. So straight away, you can kind of see that there'll be investigations. Logic says if there's fines for data protection breaches, there will be fines for failure to take this proactive duty. The extent they will be, who knows? Like, data protection breaches are really high. Whether it will be the same here, do not know. And again, another doubt that has been raised, concern, is that the EHRC just won't have the capacity to really deal with these issues. It's been a concern with the ICO for many years, although they're getting better now, that they're just a small body. They can't really govern the whole of the UK, every employer, to ensure they're complying with this. So there's still going to be a duty on employees to report breaches. And I'll come on to that a bit later, because that's one of the concerns actually raised, that sexual harassment in the workplace is woefully underreported for various reasons. Enforcement as well. In the consultation, there was discussion about whether individuals can bring standalone claims against employers for not taking these proactive steps. So again, the thinking was along the lines of something like the failure to inform and consult penalty, for want of a better way of putting it, for 13 weeks actual pay if they fail to take these reasonable steps. But the government have kind of, it looks like that will be shelved, and said they anticipate, and that's the word they use, anticipate, so it's not definite, that individuals will still only be able to bring claims in the tribunal against their employers if there is actually an event of sexual harassment. So although this is a very proactive duty, the extent to which you'll be liable if you don't engage in it is completely unknown at the moment, and that's hopefully where we'll get a lot more guidance as this goes through the various readings of the bill and it's drafted in legislation. It wouldn't surprise me if this does come out separately to the employment bill, because it feels like there's a lot to be dealt with still in this piece of legislation compared to some of the other rights where they can take parts from previous legislation for the drafting. This is a completely new duty. At the moment, it is just for sexual harassment, which begs the question as to why aren't other types of harassment going to be protected in the same way? They're just as serious. It might be. Again, we just don't know whether it will apply to other types, but the talk is, and the consultation was certainly mainly over sexual harassment. In the same movement, for want of a better way of putting it, it actually looks like, bizarrely, we will be returning to an old law for liability for third parties harassing employees. So if your employee was harassed between the years of 2008 and 2013, you could have been liable for that act of harassment if it took place in the course of their employment by a third party, so supplier, client, customer, and they had been harassed on 2 incidents or more. And that was very crucial. Before, it had to be 2 incidents or more of harassment before that third party liability kicked in for you. There are plans in the same bill movement for this to be reinstated, but in amended form. And the question is, well, if there's this proactive duty to prevent our own employees harassing people, will there be the same kind of exemption of we won't be liable for third parties until there's 2 or more acts of harassment? The two don't seem to really match up very well together. There's a lot of thinking that employers can only really be liable if they're aware of something going on, but it might be 1 sole previous act of harassment before they're then liable moving forward. So essentially, if you become aware of anything, you must take action to make sure it doesn't happen again. If you don't, you'll be liable. It will be proportionate to the assumed level of risk in a particular job, taking into account that actually different work environments are very, very different. So bear in mind, if you work in a pub, people drink alcohol. Alcohol makes people do very stupid things. It shouldn't happen, but it does, and that's recognised. It's not condoning people's behaviour when they drink, but there is kind of an assumption that actually there is a level of risk you just take and is inherent in that type of job, compared to if you're sitting in an office, you just would not expect anybody to sexually harass you in any culture situation. So that is going to be taken into account for employers, because is a pub landlord going to have to be liable for every single incident of sexual harassment in its workplace from someone who's very drunk and just an idiot? How far will that extend? So they have said that that will be recognised. And there will be the defence of the employer having taken all reasonable steps to prevent the harassment as well. So the guidance will be in the EHRC code. It will be kind of possibly mirrored from the previous rights with a few exceptions. That's really going to be where employers need to look at the code once it gets published. Only then will you know quite how extensive this is going to be. And again, we don't know whether it's just going to be for sexual harassment or all types of harassment. Very briefly, I did want to bring to your attention, because this has kind of gone under the radar, the EHRC technical guidance that was published in January 2020. It's one of those things that no one has really looked at, because a month later, the pandemic started to hit and this kind of just disappeared into the ether. But there's a few comments in it where I was reading through, and it really does kind of set out the intention of governments. I think it's well worth people going to have a read, and that's why I've put the link on the slide. But if you Google EHRC sexual harassment guidance, it will come up. This is where they said, in all the research they did, that there is a massive underreporting of harassment in the workplace. So that's why they want to step it out. They feel like the balance has gone too far in employees having to report it to the employer before anything is done about it. And employers actually need to start actively engaging in this. And the other thing which will come into the taking all reasonable steps is that they very clearly stated that although the size and resource of a company will always be taken into account, the mere fact you're a small business will not exempt you. So the pure size of a business is not a defence. And time again, we do see in defences, when we're acting for individuals, the employer will say, well, I'm a very small business. We've got a policy on the internet. What more do you expect us to do? We don't have any time to deal with this further. That is not going to be enough. And they very clearly stated this in January 2020. And we don't even have the legislation for the new proactive duty yet. So you can see that it is going to have to go much further than those basic steps. And simply having that, we're a small business defence, isn't going to wash anymore. Quite conscious of the time, so just very, very briefly, there's so much that could potentially change in the employment bill, and otherwise this year we've tried to focus on the main ones. But something that's not proposed to be in the employment bill that could still happen is potential regulation of non-compete clauses. So prohibiting your employees from working for a competitor for a period of time after they leave. There was a 2020 consultation on this, and then again, it's not gone any further because of the pandemic. But possible proposals within that were making these clauses only enforceable if you pay your employee for that period that you want them to not work for their competitor. Because of course, in certain industries, there are limited numbers of businesses that they could work in. It really does affect their ability to carry out their job, their profession. So if you need that protection, you have to be willing to pay. And in reality, we've already seen a movement towards that. So those employers who want to really try and argue that clause is enforceable are already paying employees for that period of protection. The other thing they spoke about was taking them away full stop and not allowing non-compete clauses, which has happened in some other countries. There was quite a lot of resistance from that. I don't think any company would like it. It's just moving towards, you have to really think about why you want it, make sure it's drafted well, who really is a direct competitor, make sure you use it appropriately. And it's just bringing the balance back, because I think it's gone too far to the employers. Everybody puts them in contracts without really thinking about A, whether they're needed for every role, and B, whether they can be limited. And I still see contracts where it's 12 months, you cannot work for a competitor. That's completely unenforceable. Generally, anything more than 3 months at the moment won't be enforced by a court unless you're paying the individual. So wait to see whether the government do anything further on that, but given how much they're having to deal with in the legislation, it might be something that's pushed back a year or two, or a further consultation, because there have been 2 or 3 of these over the years and then nothing seems to happen. But it's just beware of that. And then very briefly, because I can never seem to get through a webinar or seminar without talking about right to work checks. It comes up every single time, just shows the importance of it. But through the pandemic, people were allowed to do at length checks, basically on work to right documents, electronic checks. As of 6th of April 2022, you have to go back to physically checking that documentation again. And as I always say, make sure you do it before an employee starts work. It has to be before their usual start time. So the age-old thing that I say, if a normal employee's normal start time is 9 a.m, do it before 9 a.m, even if they start work at 9:30 on their first day. If you check it at 9:30, you won't be covered by the statutory excuse. So do it at second interview stage, or ask them to pop in once they sign their employment contract. Easiest way to do it. And then, although I've said you have to do manual checks, there's always exemptions. So for those who hold biometric residence cards, biometric residence permits and frontier work permits, they can only be done using the Home Office's online right to work service. And that's logically because they're electronic documents, are much harder to actually check the validity in person. So have to be done through that service. Very easy to use. If you don't know how to use it, just let us know, we can talk you through it, but it's quite self-explanatory, but just be aware they're the exemptions. So, bit of a whistle stop. Try not to speak too quickly, but not too slowly either, so I got through everything. It just gives you a flavour. Things are changing. We haven't had much new legislation for a long time, and it's coming through. It's why it's the employment bill rather than a bill for a specific right. There's lots to fit in. And as the year progresses, hopefully we'll have more detail and a better idea of when all these rights will come into force. So, does anybody have any questions?
Oh, thank you so much. I think there's a lot of information here from both of you today, but it's been really clear, really like to the point and very concise. So I'm sure it's meant a lot to a lot of businesses here today. We do have a couple questions here in the chat. So we had one here from Keith who asked, is it discriminatory to have 2 different levels of sick pay based on your vaccination status?
Good question. You hear my pause, Andrew?
Yeah, I had the benefit of seeing that question when you were speaking, Tessa. So if you want me to go first, I'll mess it up and you can come back. I think the answer to that is, in principle, no. But if in fact you, I suppose the caveat to that would be potentially the disability aspect. So if it is that someone is not being vaccinated because of a disability and they have medical exemptions, in those particular circumstances, I'd be more concerned about the potential for discrimination. But generally, I think whilst it is discriminatory, it's not necessarily unlawful discrimination. That's the difference here. And I think the unlawful element is more likely to come in the case of a disability issue. Tessa, do you agree with that? Is that your...
Yeah, that's all logical. And you'll see lots of companies are obviously doing this quite notably. Some big names have introduced this in the last couple of weeks. So they will have had lawyers think this through before they've introduced these schemes. It probably gives you the answer.
You should hope so anyway. And we had another one here from Jenna, who asked, I think it's going back to when we were talking about carers, would they have to prove that they are a carer?
Not at present. So there's no proposal at the moment that they will have to prove that relationship. They may have to make a signed statement that they're a carer. So if they're lying, that would be a conduct issue to deal with as the employer, but no proof, because logically that would be quite difficult to provide. What would that proof be? And given its own, I say only for 5 days a year, it's quite a small right compared to having to take a year off. So no, not at present.
Brilliant, thank you. And I think the last question that we have here, unless anyone's about to pop any in the chat, was from Karen, who asked, what about online DVLA checks? I'm assuming this was going back to, I'm not too sure. Karen, I'm not too sure if you're still here and want to unmute and maybe expand on your question a little bit.
We actually pay a company to do online license checks of the DVLA. So we buy a number of credits annually, and it's to do with the last point about the right to work and online checks stopping from April.
So I take it for this is the license to drive vehicles if it's DVLA.
Yes, and to see how many points they've got on their license.
Yeah, so that will be able to continue because that's not their right to work in the UK per se. It's their right to be able to carry out that job. So yeah, that will still be fine. It's only the right to work, their right to be in the UK full stop that needs to be done manually.
Fantastic, thank you.
Thank you. It looks like we've got one more here from Judith quickly, who said, when did/does the unpaid carers leave take effect?
Good question. We don't know yet. As with all these things, we don't know. The carers leave seems to be a bit further ahead than the other rights that are going to be introduced. So I'd be hopeful that it's this year for that one. Potentially October. The government do like the traditional April and October introduction dates for legislation. So potentially that one later this year in October. I don't think it'll be ready for April.
Brilliant. Thank you so much for that. It looks like we don't have any more questions from anyone. So I guess that just leaves me to just say again, a huge thank you. Like I said, there's been a lot of information today, but it's been really informative and really clear. And I'm sure it would have helped a lot of businesses today. So I suppose just to remind everyone as well, we are recording today, so that will be soon on our Kent and Victor Chamber website if anyone does want to watch anything back. Otherwise, again, a huge thank you to you both, and hopefully see you all soon.
Thank you.